Lesson: Liquidated damages versus penalty clauses. In contract law, the distinction between liquidated damages and penalty clauses is crucial for understanding how parties can preemptively address breaches of contract. Both are types of clauses that specify the amount or formula for determining compensation if one party breaches the contract. However, their enforceability and purpose differ significantly, impacting contractual relationships and dispute resolutions. Liquidated damages are predetermined sums agreed upon by the parties at the contract's inception, reflecting a genuine pre-estimate of probable loss in the event of a breach. Their primary function is to simplify the process of compensation, avoiding the need for lengthy and expensive litigation to ascertain the actual damages suffered. Courts generally enforce liquidated damages clauses as long as they are a reasonable estimation of the likely damages at the time of contract formation. This enforceability hinges on the clause not being punitive in nature, which brings us to penalty clauses. Penalty clauses, in contrast, are designed to punish the breaching party rather than compensate the non-breaching party for a loss. These clauses impose a detriment on the breacher that is disproportionate to the actual harm caused by the breach. Historically, courts have refused to enforce penalty clauses, viewing them as punitive rather than compensatory. The underlying rationale is rooted in the fairness doctrine, which seeks to prevent unjust enrichment or oppressive penalties that exceed the actual damage incurred. A practical tool for distinguishing between liquidated damages and penalty clauses is the reasonableness test, which examines whether the sum stipulated is a genuine pre-estimate of loss and not extravagant or unconscionable. This test was articulated in the landmark English case Dunlop Pneumatic Tire Co. Ltd. v. New Garage and Motor Co. Ltd., where it was held that a clause is a penalty if it is extravagant and unconscionable in comparison to the greatest loss that could conceivably be proved to have followed from the breach. Another useful framework is the proportionality principle, which assesses whether the stipulated damages bear a reasonable relationship to the anticipated injury. This principle is particularly relevant in jurisdictions like the United States, where courts often apply a two-pronged test. First, determining if the harm caused by the breach is difficult to estimate at the time of contract formation, and second, whether the liquidated damages are a reasonable forecast of just compensation of contracts Baxter 356. This approach underscores the importance of careful drafting and foresight in contract negotiations. For professionals engaged in drafting or evaluating contracts, several actionable insights can enhance proficiency in handling liquidated damages and penalty clauses. First, parties should aim for clarity and precision in drafting these clauses, ensuring that the language reflects a genuine pre-estimate of loss rather than an arbitrary or punitive sum. This involves conducting a thorough analysis of potential risks and damages associated with a breach, supported by empirical data or expert opinions. For instance, in construction contracts, liquidated damages might be calculated based on the anticipated daily loss of revenue if a project is delayed beyond the agreed completion date. This calculation should be documented and justified to withstand judicial scrutiny. Moreover, professionals can benefit from employing a checklist approach when assessing liquidated damages clauses. This checklist should include considerations such as the nature of the contract and the breach, the predictability of damages, the presence of any mitigating factors, and the proportionality of the stipulated sum. By systematically evaluating these factors, parties can ensure their clauses are legally robust and aligned with judicial expectations. Case studies further illustrate the practical application and challenges of liquidated damages and penalty clauses. In the case of Phillips v. Attorney General of Hong Kong, the court upheld a liquidated damages clause for late delivery of flats, as the sum was a reasonable estimate of the loss of use of capital and inconvenience. Conversely, in the Australian case of Andrews v. Australia and New Zealand Banking Group Ltd., the High Court ruled that certain bank fees were penalties, as they were disproportionate to any loss suffered by the bank. These cases highlight the nuanced interpretation of such clauses and the importance of aligning them with contractual intent and reasonable expectations. Statistics underscore the prevalence and impact of liquidated damages and penalty clauses in commercial contracts. A survey conducted by the International Association for Contract and Commercial Management found that over 60% of contracts include liquidated damages clauses, reflecting their widespread acceptance as a risk management tool. However, the same survey revealed that disputes over the enforceability of these clauses are among the top 10 causes of litigation in contract law. These findings emphasize the need for clear and enforceable clauses to mitigate legal risks and foster contractual certainty. In conclusion, understanding the distinction and application of liquidated damages versus penalty clauses is paramount for contract law specialists. By employing frameworks such as the reasonableness test and proportionality principle, professionals can navigate the complexities of these clauses and enhance their contractual strategies. Practical tools, including empirical analysis, checklists, and case study evaluations, provide actionable insights to ensure clauses are enforceable and aligned with the parties' intentions. As legal landscapes continue to evolve, staying informed and adaptable in the application of liquidated damages and penalty clauses remains a critical competency for contract law professionals.